Assalamualaikum warahmatullahi wabarakatuh. This is part 3 for the Zoom recorded lecture for the topic capacity to contract, which focuses on minus contract. In the previous part, we stopped at the necessaries. Okay, I mean that here for necessaries, minors are bound or legally bound to restore or make reimbursement. Okay, to pay. In other words, minors has to pay or can be imposed with reimbursement. Now we want to focus on marriage contracts and then followed by employment. Okay, whatever employment contracts entered into by minor. So similar to necessaries, okay, marriage contracts actually it falls under the exception to the general rule. Because what's the general rule? General rule is that all contracts entered into by minors they are void. But when we talk about marriage contracts, it falls under the exception. So we don't apply the general rule. Okay, it's not applicable here. How do we know? I mean, what's the position in Malaysia? Section 4 is the relevant one, the authorities. So Section 4 of the Age of Majority Act 1971, it provides clearly that nothing in the Act shall affect, okay, inter alia, first, okay, the capacity of any person to act in the following matters, namely marriage, divorce, dower, and adoption. And by virtue of Section 2, by virtue of Section 10, Section 2 of Contracts Act 1950, a minor may sue and be sued for breach of promise to marry. So it falls under the exception. Okay, let's go to the case, very old case here. The case is Rajeswari and another, and Balakrishnan and others. So in this case, the court made it clear expressly held that contracts to marry entered into by minors are distinguishable. So it can be differentiated from other classes of contract. I mean, it falls under the exception, clearly. So the plaintiff, the minor in this case, could maintain, could maintain an action on the agreement entered into between her father as her guardian. I mean, here when the contract was entered into, it was done by the father. But the contract, it was her contract, but the one who entered was the father as guardian for her, okay, on her behalf. And the first defendant, whereby the latter, okay, promised to marry the minor. So there's a breach later, okay, breach of promise to marry. So the minor has the right to sue, has capacity, legal capacity to maintain an action. Okay, we go to the another category of contract here, minus contract for employment as well as apprenticeship. Okay, what's the meaning of the word apprenticeship here? So basically, apprenticeship, it refers to someone who has agreed to work for a skilled person, okay, for a particular period of time and often for low payment in order to learn that person's skill. So that's the meaning of apprentice. More or less, it has connection with training lah. Okay, but now you get training from a skilled person, okay, and a certain specific of time, and usually no payment or very, very low payment. Okay, so what's the position of law, okay, as far as the contracts of employment is concerned involving minor? So both child and young person, so we have two categories of minor here, child as well as young person. This is for the purpose of employment. Okay, so both of them are eligible to enter into an employment contract. But of course, we have some regulations, okay, regulatory provisions in the contract. So we're going to have a look at the section 1A. Okay, A is amended of Children and Young Persons Employment Act 1966, revised 1988. And we are going also to refer to section 13. So section 13, they talk about competency. So any child or young person shall be competent to enter into a contract of service and may sue as plaintiff without his next friend or defend an action without a guardian ad litem. So a minor can take action in his or her own name. Okay, no need to bring in, we call it next friend. That's the term under civil procedure, next friend or guardian ad litem. You can do it personally. So what's the meaning of the word contract of service here? So contract of service is agreement in which one person agrees to employ another employer, okay, as an employee, and the other person, employee, the minor, agrees to serve the employer as an employee. So can minor enter into such contract? Yes, by virtue of section 13. So this is the actual wordings of provision. This is, I just reproduce here, okay, for the purpose of easy reference. So section 1A, it talk about interpretation. It interprets the word. Okay, child means any person who has not completed his 15 year of age. In here, 14 years, 14 and below. And young person means any person who, not being a child, has not completed his 18 year of age. In here is between 15 to 17. So it's considered as young person. And section 13 specifically covers contextual capacity. You can have a look later. You can read actually here, but we have discussed in the earlier part or in the previous slide. Okay. Now we want to know the position in England. Here, position Malaysia, position England, because sometimes there's a differences. Okay? Sometimes we just follow, we just adopt the position in England. So in England, the approach is slightly different because why? Labor or employment contracts, okay, have been held, okay, to be within the class of contracts for necessary. So in other words, they are valid. Okay, so because of that, the key contract for education, service, or apprenticeship are valid. Okay, they are not considered to be void. Okay, as compared to Malaysian position. And again, okay, the court will look whether the contract as a whole will be beneficial to the minor. But again, the court will look at the terms, okay, whether it is onerous, burdensome to the minor, whether it's unfair or not. Okay, the court will examine all the situations. But as a general rule, it will be considered as valid because why? It falls under categories of necessaries. Next slide. Okay, this is a very, very classic case pertaining to apprentice actually. Okay, training given to the minor. The case name is De Francisco and Barnum, 1819, okay, 19th century case. So a girl, the minor, okay, entered into a contracted with signer De Francisco to be taught to dance. So that's, I mean, to train to be a dancer, okay. And the contract provided that she should be entirely at the disposal of the master, that he should not pay, I mean, the master should not pay her, okay, unless he actually employed her, okay. And then she was not to obtain engagement or to marry without his consent, and he could put an end to the contract at any time. Okay, so that's all the terms of apprenticeship. Okay, entered into between the one who provide the training, the apprentice, as well as the minor, okay, the girl. And when the case was brought to the court, okay, there's a problem later. So the court looked at the overall, the court examined closely the terms, okay, and whether it give benefit, okay, overall benefit to the minor. So the court held that, this is the court analysis, the court analyzed, okay. So the court came to the conclusion that it is, whatever terms here, it is for the minor's benefit, that he should be able to obtain employment, which will be difficult, okay, if he could not make a binding contract. This is in general, okay, he or she here, okay. And then the law will allow minor, okay, to do so, provided the contract taken as a whole is manifestly for his benefit. So even though maybe apparently the terms looks unfair, but as a whole, does it benefit, okay, in long term, for example, does it benefit the minor? So the court will examine all the terms. We have another case, also very, very old case here, classic case, another 19th century case involving minor as well. Clements and London and Northwestern Railway. So the minor here was hired, he was employed as a young, a railway porter, obviously very young, okay, because a minor. And the minor, when he served, okay, he worked as a railway porter here, he agreed to join an insurance scheme. And by joining this insurance scheme, he will forego, okay, he need to forego or let go any claims, okay, that he might have under Employers Liability Act. So because of that, he had forfeited his rights under the Act. And the court look at it, okay, whatever action here. So actually the contract as a whole, actually for his benefit. So he joined the insurance scheme for his benefit, despite the fact that he forego all the claims under Employers Liability Act. And this is the actual quotation from the judgment here, okay. Contracts of apprenticeship and with regards to labor are not contracts to an action on which the plea of infancy is a complete defense. I mean, here, minor cannot plead infancy later, cannot say, oh, when I entered into a contract, when I agreed, okay, to be bound, actually I was a minor, I was an infant, okay. And the court said, well, the question has always been here both at law and in equity, because at common law, I mean, in England, they have two categories of court, okay. And then whether the contract, this is the main consideration, okay, the main question, whether the contract, when carefully examined, okay, in all its terms, is it for the benefit of the infant? And if the answer is yes, okay, if it is so, then the court, which the question comes, okay, the court will not allow the infant to repudiate, okay, to terminate the contract. Okay, if the provided all the terms here, okay, the term actually for the benefit of the infant as a whole. Okay, that's the observation by the court. Okay, we stop here. We are left with one more part, the final part of the discussion for this topic. I'll see you at the next part. In the next part. Assalamualaikum warahmatullahi wabarakatuh.